Hi, I'm Rebecca Chen, and I'm here with Rahul Reddy, virtually, obviously, as you all can see. Apologies also for our delay this afternoon. We had some technical issues. As you can see, our setup is a little different in light of the sharp rise in COVID cases that is going on in Texas, especially the Houston-Harris County area. We are reporting to you remotely, separately today for safety, but thank you for joining us, and we'll be providing updates as we do every Tuesday on any immigration ongoings. So Rahul, what do we have for today?
Yeah, today we're going to discuss about the furlough of the USCIS employees. They're speaking about 13,000 USCIS, the Immigration Service employees furlough. The second topic that we're going to discuss about is that what are the short-term implications of the executive orders? What are the long-term implications of the executive orders, especially on the business immigration? The third thing we are going to discuss is what about if it is, can we apply for a B2 visa instead of applying for a H4 visa? These are the main topics that we're going to discuss. Now, Rebecca, this furlough of USCIS employees, what do you think so this administration is coming up with? I mean, they're saying that there are not enough applications that they're receiving it. How truthful they are, and why is it that we don't see that? I mean, we see the applications have gone up. The number of people who are stranded in United States right now has gone up by about 3 million people, according to the stats, that they could not leave the country because of the pandemic situation that they are in. And they are filing B2 applications, B2 extensions have gone up significantly high. What are they speaking about?
Yeah, so we know that USCIS, the agency that processes most of the immigration benefits in the U.S., has gone to Congress recently asking for a $1.2 million injection of funds that they are claiming is needed to prevent a furlough of, I think, over 13,000 of their USCIS employees. The reason that USCIS is given for the need for this fund injection is that applications and petitions filed with USCIS have, in their claim, sharply dropped since the pandemic, and that has resulted in a drop in funding for USCIS because USCIS is a primarily fee-based, fee-funded agency. They, for the most part, don't receive tax dollars from Congress, which is why whenever there's a government shutdown, USCIS, for the most part, is not affected. They continue processing because every application or petition that you file with USCIS has to have that filing fee check attached to the top. So that is usually what makes USCIS operate, those filing fee checks. In our experience, we have not seen a drop in cases, at least not such a drastic drop within the past few months that would, necessitate this $1.2 billion influx of funds from Congress or a furlough. What we believe and what we have discussed in these Facebook Live and YouTube Live sessions in the past is that USCIS, we know that they have had budget issues since last year, kind of throughout the administration, this term of the administration. We've seen USCIS implementing more and more requirements on applications, more hoops to jump through, more paperwork, just more in the process of getting the same immigration benefit. Just some examples are the biometrics requirement for all I-539 applicants that was implemented last year. A couple years before that, it was the requirement that all I-485 applicants be interviewed in person before they receive their green card, including employment-based, which for the most part, those were waived for years and years. Just all sorts of additional requirements. The I-944 requirement that each applicant for a green card go through an extensive credit check. This is all not only extra work for the applicants, but extra work for USCIS. They have to go through these additional forms, these additional processes, and it seems that it is bankrupting them to some extent. So, but the claim that the agency doesn't have enough to work on doesn't seem true. We know that there are extensive backlogs of applications pending with USCIS right now. Rahul, we were checking some of the processing times just earlier today. What were some of the years-long processing times for some applications in some cases? So this is the most recent news is that USCIS is planning to furlough these workers as of, I believe, August 3rd. This, if it occurs, is just going to add to the already long backlogs for some of the processing times that we're seeing for, in particular, I would say I-539 and I-485 applications.
Do you advocate for Congress to grant them the money under the circumstances?
That's hard to say. If they do, Congress should definitely attach conditions to the funds, such as making USCIS abide by reasonable processing times for some of these form types. We know that it doesn't take 10 to 12 months to process an I-539 application because we've seen USCIS process one faster than that before. So I would say if Congress does, of course, we don't want federal workers to be laid off. That would only add to the unemployment situation right now. And it would be bad for the applicants, people who have applications pending with USCIS. It's just going to add to their processing time. So if a furlough can be avoided, I think that would be in everyone's best interest. But I think Congress should attach some conditions for reasonable processing times if they do provide these funds.
One thing I feel very bad about the whole thing is to fund or not to fund this whole administrative policy to have USCIS get into the situation. I recall back in olden days, back in Clinton time, at that point of time, for example, some of the things that you said is that the 485 application for the employment-based, there was no interview requirement. This was bought because of Bush administration, the junior Bush administration. Now, all those policies were being implemented. Most of these things were implemented to expedite the things by Bush administration. I recall in the Clinton administration, the things used to be very bad. To get the adjustment of status done in the district centers, for example, if a US citizen marries a person who's visiting from outside the country, and when they file the adjustment of status, though, it used to take 4.5 months in Houston, Texas. And also for those people in Houston, Texas, if they file an adjustment of status in the employment-based category, at that time, the interview was required in the Clinton administration. It used to take 4.5 years for them to get the green card application approved under the adjustment of status after the I-140 has been approved and the prior date has been correct. Now, when Bush administration came in, he wants to straighten up the things, want to get the things done better. So what he did was that he gave a mandate as soon as he entered into administration, which is on January 1st. He signed, he sent a declaration to the administration that in the next 6 months, he wants to bring down the timings of the adjustment of status and all other application status down. He wants to bring them down within the next 6 months. Guess what happened, Rebecca, at that time? This USCIS at that point of time, they didn't respect Mr. Bush, what his request was. They didn't. In the next 6 months, it moved from 4.5 years in Houston to 4 years and 9 months. This guy is a born-again Christian, or at least he claims to be coming from a Texas state, and he gives an order, we are going to follow it. They didn't follow it. Guess what? President Bush did it. He fired all district directors. He said, you're all fired because you don't know how to work. And he didn't fire them immediately. He fired them, you're fired 6 months from now. Guess what happened, Rebecca? From that time they received the firing orders, The processing times went from 4 years and 9 months to 3 months in 6 months. In 6 months, 4 years, 9 months to 3 months. We beg the USCIS, please don't adjudicate these applications, especially when we want to prove that the marriage is genuine and all those things. We need to give some time to live together for them. Don't adjudicate so fast. We have to request them to slow down because they got fired and they cut down the time. So, and then he actually, Bush administration, then he took half the interview requirement at that point of time, saying that it's unnecessary for the employment-based people. Now, Trump administration brings it back. He knows it. That's the way to delay the entire thing. That's a way to delay the entire thing. He can't deny it, so he's delaying the process. So this administration intentionally bankrupted USCIS. Now, even if the Congress gives the money, if they don't put any conditions on it, it's going to be a nightmare. It's not going to be good for our customers. It's not going to be good for the country at all. So I think so that the Congress should not fund the entire amount, should fund it very limited and put so many conditions that they should cut down the times based on cutting the time of adjudication only. Will they get the funding? They should benchmark the money that if you cut down this much timing, you're going to get this much funding. Anything on that? And let me tell you, our audiences, some of the processing times of the USCIS right now. I'm reading it from the USCIS processing time, guys. This is from California Service Center. If a brother or sister files for an I-130 application, they are taking 138.5 months to adjudicate that this is a brother, this is a sister. All they are determining is the brother and sister relationship. That's all. To determine that this is a US citizen, which the naturalization certificate is so clear that this person is a US citizen or the passport. And then to determine the brother and sister, they're taking 138 months. That's more than 10 years it is taking for them to adjudicate the I-130 application. Now, then the Trump administration keeps claiming that he's very business friendly and all those things. The I-529-26 application. This is for the investor immigration purposes. It is taking 61 months for them to adjudicate the application, where people spend millions of dollars to get into, to file this application, and they are taking 61 months to adjudicate the application. Where are they telling that they don't have enough cases? There's something completely wrong.
Yeah, there's definitely a disconnect between the justification for asking for the additional funding and what we are seeing, on the ground as far as processing times for cases. So the next thing we wanted to go over briefly is the long-term implications of the executive order that went into effect last week as of June 24th. So we have discussed last week the immediate effects, which are the suspension of applications for visas at overseas consulates in certain visa classes H, L, J, and the long-term implications we mentioned a little bit last week are mentioned in Section 5 of that proclamation. Those are ones that could potentially impact H and L applications that are filed with USCIS. So as we've stated before, right now, the effect of the order that is in effect right now primarily applies to individuals who are outside the U.S. who want to apply for a visa at a consulate. That is not possible right now in those certain visa classes. However, the executive order also hinted at additional steps that it looks like the administration is contemplating to changes in the Perm process, for example, for EB2 and EB3 green card applications, and the LCA requirement for H-1b applications. Those are not new requirements. Those have been around for years, but they were specifically referenced in the executive order as potential areas where the administration is asking the agencies, the Department of Labor and DHS, to look into ways to further protect American workers using the Perm requirement and the LCA requirement. So those requirements require employers to try to recruit a U.S. worker first before they can sponsor a foreign national for a green card in the EB2 and EB3 categories. And the LCA, of course, requires that H-1B employers offer the H-1B employee a minimum salary, the prevailing wage, according to DOL. So it does appear that we may see potential changes, maybe higher scrutiny or heightened requirements in those two areas. If those changes do come about, as we've also said before, they will be through the regulatory process. So there's a very specific kind of usually months-long process that any changes to the Perm or LCA would need to go through first. There would be a proposed regulation first. The government is required to receive public comments on that proposal, take those into consideration, and then publish its final regulation with justification on why they are changing the regulation. So there would be a lot of notice before there are any changes like that. It would not be something that would just be announced and go into effect the next day, the way that the suspension of entry is.
Rebecca, are you sure that this executive order is going to stay only until December 31st of 2000, or can it be extended?
Yeah, the order leaves room for it to be extended or renewed, just like the initial order issued in April was initially for 60 days, and this order is technically an extension of that April order. So whether this order goes on beyond the end of this year, I think, of course, will depend on the election. Whether we have an administration change, we would assume that a new administration would most likely not want to continue the executive order. We'll have to, it depends on a lot of factors. But if it is possible that the order could be renewed if the conditions for the order continue to remain. And the conditions that are given in the order, of course, are the high unemployment rate among U.S. workers right now. So it'll depend on, I think, the election, on the economy at the time. So it could potentially be extended.
Rebecca, on the issue of the applying B2, for example, if somebody is a spouse of the H1 person, and can they apply for B2 in the consulate, because the executive order does not prohibit B2 applications to either get a visa or enter the United States?
Yeah, so we have gotten that question quite a bit for spouses of H-1B workers who are unfortunately stuck outside the U.S. right now and do not have an H-4 visa stamp in their passport already. Because of the executive order, they're not able to apply for an H-4 visa for the rest of this year, even when consulates reopen. So we have been asked, is the B2 visa a possibility in that case? I would say for the most part, it is not. We have, kind of advised people on an emergency B2 visa for very limited kind of humanitarian sort of extraordinary circumstances situations. In general, though, the B2 is not really an alternative for an H-4 visa. If you're applying for a B2 solely because you intended to apply for an H-4, but it is not available right now due to the executive order, that is not really a valid reason for applying for the B2, and it could be potentially damaging to your future immigration process. The B2 is really a very limited visa. You're supposed to come in with the intention to stay temporarily, not to stay or work or eventually immigrate to the U.S. So if you or your spouse has the green card process started already. That could also be a hindrance to the B2. And if you use the B2 to come in and then end up trying to change to a different visa class or something like that, it could, like we said, have long-term implications for your immigration process, because you could be found to have misrepresented your intent when you used the B2 visa, and that could damage your immigration process for years to come, because it's very difficult to overcome a misrepresentation finding.
Rebecca, is everything bad or anything positive that can come out of all these executive orders and Trump administration, especially for the Indian immigrants who have been waiting for a long period of time?
Yes. So actually, one side effect of the executive order is that we may actually see we almost definitely will see forward movement in the employment-based priority dates in October, at the start of the new fiscal year, when it starts in October this year. That is because the executive order that has been in effect since April bans immigrant visas. It bans green cards from being applied for at consulates overseas. A lot of those green cards that are applied for overseas at consulates are for the family-based category. Since those are not available or cannot be applied for the rest of this year, there's going to be a number of unused family-based green cards for this fiscal year. And when there are unused family-based green cards in a fiscal year, the next fiscal year, they spill over into the employment-based category. So based on information from the visa chief at the Department of State, Charlie Oppenheim, who updates the Immigration Lawyers Association periodically with what he kind of predicts will be movement in the visa bulletin, we are anticipating that there will be an increase in employment-based green card numbers for this next fiscal year. We're expecting to see movement, I would say, definitely in EB1 India, and hopefully EB2 and EB3 as well, but we can't say for sure or by how much the forward movement could be.
Rebecca, before we go to Q&A, you have anything else?
I think that was mostly it for our updates this week.
I'm getting questions from YouTube. Uma is asking this question. I'm on a H-1b, I got furloughed today. When will the 60-day grace period start? Uma, I'm assuming that your I-94 is still valid for the next at least 60 days, because that is absolutely required for you to use the 60 days. So if your I-94 is valid for more than 60 days, your 60 days started from the time your furlough started. So practically there is no furlough here for H-1B. It's a termination of employment on the H-1B. So your 60-day grace period has already started.
Yeshwant from Facebook is asking a question that we've been getting a lot recently. He had his H-1B selected in the lottery this spring, and it sounds, hopefully you've gotten that application filed, because the deadline was today to file that petition based on your lottery selection. He's asking, is there any impact based on the executive order? At this time, no. At this time, applications that are filed with USCIS that were selected in the lottery, even ones that were not selected in the lottery, extensions, amendments, transfers, applications filed with USCIS at this time, there is no direct impact based on the executive order, because like we said, the order affects people who are going to need to apply for visas at the consulate. That could potentially be someone who was selected in the lottery, because you would have an H-1B application filed with USCIS. And if you are outside the country right now, before you can come in and start working for your new H-1B employer, you would need to get a visa at a consulate. So that affects those people. But if you are here in the US now in valid status like F1, And if your employer requested a change of status for you in the petition that should be filed by now, that can still be processed by USCIS as normal. And the change of status can go into effect October 1st if it's approved by then. Our main advice would be to not leave the country until the executive order is lifted, because if you leave the country, then you'll be stuck. You'll need a visa at a consulate before you can come back in, and that can't happen until first consulates reopen and then second the executive order is lifted.
A question from Mr. Iyer is that the person has I don't know which is maybe his parents have received a B2 visa from the consulate in 2019. Is there any restriction for them to travel into the United States? The answer is no. There is no restriction, none whatsoever at all, for the B2 visa people to come into the United States. If a new applicants are applying for B2, other than consulates being, right now because of the COVID situation being closed, but there's no restriction that no new B2 can be issued. There's no such restriction at this point of time. People can still get the B2 visas right now. Now, however, I do caution one though. If you are married to a US citizen, even if you have a B2 visa, before you embark on the journey, do consult an immigration lawyer privately. Not in this one, because you may not be even allowed to enter onto B2. That may also violate the terms of the B2 visa for which you have been allowed that visa. So if you're married to the H1 person, though, I want you to contact a lawyer before you enter the United States. Another question that came out from Sumant from Facebook is that the B2 receipt notice has not been issued at this point of time. And the I-94 B2 extension receipt notice has not been issued at this point of time. And the I-94 is expiring in 2 days. What to do? Well, first thing is that check to see if your bank check has been cashed that you have sent along with the B2 extension. If you cannot see that thing, what I would suggest to you right now is to file another I-539 application, and this time do it online. And if you do it online, you'll get a receipt notice then and there itself. In that way, you're secure that the person has filed extension in the proper timings, so that if you don't file the extension in the proper timings, it means that you have overstayed your visa. Once you overstayed your I-94, then they consider that your passport visa is invalid. So if somebody has a 10-year B2 visa on their passport stamping, and they overstayed for 2 days after the I-94 expired, that means that their passport visa is invalid. Then when they go outside the country, they have to get the passport stamping again. To avoid all these things, I would request that you file an online application again. If I were you, I don't mind spending that extra money filing it online rather than risking my visa stamping, so that I don't have to risking my visa stamping.
So we have a number of questions about the biometrics appointments and the ASC's reopening. So yeah, those have been closed since March due to the pandemic. It was initially announced that they would be reopening in June, and that has not happened yet. So if you are worried that you missed your appointment notice rescheduling your biometrics appointment, don't worry. As far as we know, those have not been going out yet. The most recent news from USCIS is that the ASCs, the application support centers where the biometrics are taken, will begin a phased reopening on July 13th. So probably in the next couple of weeks, the appointment notices for kind of the first people who will have rescheduled appointments will start going out to home addresses and attorneys' offices. So you can start being on the lookout for those, but no one has had their interview scheduled yet as in June. It seems like a phased reopening. We don't know exactly what that means. Phased as in maybe only a percentage of ASCs are reopening, or they're all reopening, but with limited capacity. We're not quite sure yet, but yeah, those should start up again in July, according to the most recent update from USCIS. Do pay attention to the new appointment notice when you receive it. There are supposed to be specific instructions on the notice that everyone will need to comply with in order to kind of try to prevent further spread of COVID. So there are changes from previous procedures. One example is that walk-ins are no longer allowed. It used to be that ASCs were pretty flexible, even though you were given a specific date and time. If you missed it, you could go in on another date and time without, making a prior appointment. And if they could fit you in, they would. They used to be pretty flexible. It sounds like that will not be the case anymore. They are really limiting the number of people present in the ASCs in order to social distance and try to keep everyone as safe as possible to get the biometrics done. So make sure you pay attention to those guidelines.
Rebecca, can you comment anything on the recent amendments made to the executive order, though?
Yeah, so those came out, I believe, yesterday. They seem to mostly close sort of a loophole that we had also sort of noticed and sort of discussed amongst ourselves, amongst the attorneys in our office. Basically, from the wording of the exact wording of the order, it made it sound like if you had, for example, a valid B2 visa on June 24th, it's a valid visa, and one of the exceptions carved out in the executive orders for people who have a valid visa as of the effective date of the order. So people were wondering, well, if I have a valid B2 visa, for example, in my passport on June 24th, does that mean I can go and apply for an H-1b visa at a consulate in August? So it was my feeling from, when we first discussed it was that probably not. It was pretty clear that the intention of the order was that they didn't want any new H-1b, H-4, L-1, L-2, or H-2b or J-1 visas to be issued by consulates for the rest of the year. And so the amendment that came out was to sort of close that loophole and make it clear that what the exception meant was that if you have a valid H-1b visa on June 24th in your passport, you can still use that. So existing valid H or L or J visas can still be used for travel. But having a valid visa in any class doesn't allow you to go apply now for an H-1b renewal passport, visa stamp in your passport.
A lot of questions are coming with regards to the furlough of the USCIS employees. Will it affect the H-1B transfer applications? Since the premium processing is not expected to be turned off, we are not expecting much difference for the H-1Bs. So, particularly most of the people it's already taking 8 months to 10 months to get these adjudicated. So they may actually, since the premium processing is already there, we're not expecting premium processing to be suspended. So there is a good chance that things will not change much for the H-1B applications. But we do expect that a lot of changes, delays are going to occur on the H-4 applications, EAD applications, and a lot of other applications that may take a long time, especially those that doesn't have a premium processing are expected to take a long time.
So Bureau from Facebook has a question about additional income for someone who is in the U.S. on H-1B status. So we have gotten questions about this pretty frequently recently, also just in light of the economic uncertainty. People are looking for additional or kind of creative means of additional income. For H-1B holders, you have to be really careful. when you're here in H-1b status, you are authorized to work only for the employer that has an approved H-1b visa petition for you. That could be more than one employer if that other employer has filed a concurrent H-1b application for you. But the only employers that you are authorized to work for and receive a salary from are the company or companies that have an approved H-1b petition for you. Additional income that the viewer was asking about, one example was like from income from stock market investments and that kind of thing. So as we've said before in these sessions, kind of passive investments like investing in stocks for publicly traded companies on the stock market, that should be fine because that is not employment. That's a passive investment in a company. If it is an investment in a smaller company where it looks like you are, one of the main shareholders and that you are going to be involved in the operation of this new business or existing business, that you have to be much more careful about because that starts to look like work authorization, that you're being employed by this company, that you're, hiring employees for it or directing, doing marketing for it or anything. So if it is investment in a smaller company, I would definitely consult with an attorney before entering into that to make sure it wouldn't be considered unauthorized employment.
Nandu from YouTube has this question. He or she is on H-4EAD. Can I work on 2 jobs instead of 1 job? The answer is yes, you can. The H-4EAD does not have any restriction whatsoever at all on the amount of a number of jobs they can, number of hours they can. There's no restriction. The H-1B people, if they want to work for a second job while maintaining one H-1B, can they do another job with filing another H-1B? Yes, that's called concurrent H-1b. They can have 1 full-time H-1B and 1 concurrent H-1B. That means that they can work for 1 main company and they can have also another company that they can work. The second job, they can either have it full-time or they can have it part-time. It's up to the company and the individual. If the individual wants to work 2 full-time jobs, they can absolutely do. Sunil from Facebook has this question. He's a doctor. He already has a national interest waiver. Can he go for the H-1B stamping right now? Does the same standard of national interest waiver, what he got an I-140 approval for, will that be applicable when he's applying for the H-1B? Because they said if it is in the national interest, they may waive the requirement. They may waive this thing and then give the stamping. Sumit, I would recommend to stay away right now. The reason is that we don't know what standards that this administration is going to maintain when they are going to give you, when they consider that you are in the national interest of this country to enter into the United States on H-1B. We don't know what their standard will be at this point of time. We don't want you to be the testing case. Just wait until a couple of people who desperately have to go there, then they can approach the consulate. They should at that point of time approach the consulate to see if they would be granted in the national interest to come into the United States. At this point of time, try to avoid it. If not, if you ever have to go there and you will have to apply with the consulate for the national interest waiver, and I would recommend that you make an advance application to the consulate to request them so that they can grant the waiver. Try to avoid it. If you can't, then you will have to give them in advance to see if they will waive it for you.
Christabel from Facebook has a good question about a potential change to Perm, where there may be a requirement that that people who have already gone through the Perm process and most likely had their I-140 approved and are just waiting for their priority date now, will they be required to go through the Perm process again, or will the government try to add that requirement? So that has been a rumor kind of floating around. We do know that's something the administration has kind of floated, or there are reports out there. There are always a lot of rumors about what the administration is considering doing, what it would maybe like to do. And we do know that what appears to be the administration's practice for a lot of these changes is to kind of float what they are considering or would like to do in the news and see what feedback there is and see if it's something they can legally do, what the reaction from the business community is before they make an actual decision. So yeah, that is one of the reports that is out there, that potentially there may be a requirement to test the labor market again for people whose Perm applications were approved or certified a certain number of years ago. In our opinion, we think it would be pretty difficult for the administration to justify that potential change. Even if they proposed it, it would face almost definitely a legal challenge immediately, because the actual statute and regulations do not include a continuing labor market test. And for the administration to now impose one, for one thing, would, you know, it isn't the fault of the applicants or the employers that that they are still waiting for their priority date to become current. It's the result of massive backlogs in the immigrant visa categories. So we think that any attempt to impose that sort of additional Perm requirement would almost definitely be challenged in federal court almost immediately, and likely it would not be upheld, as we've seen with other similar, not exactly similar, but you know, the recent DACA decision by the Supreme Court made it clear that that the court views that any potential changes that have an effect on individuals in the U.S. You know, in that case, it was obviously the Dreamers. In this case, it would be, you know, a population of green card applicants who, and their employers, who have been going along in this process according to a certain expectation of what the rules are. The Supreme Court, from the DACA decision, has made it clear that the administration has to provide a pretty substantial justification and do it in a very clear way to impose any changes like that. So that kind of gives us reason to believe that a change in Perm like that would most likely not be successful if the administration were to propose it.
A question that came out from Arvind. It's not a question, but Rebecca, I need your attention on this one. I checked, I verified what Arvind was making a statement. That Arvind from Facebook is making a statement that the processing time for the H-1b of California Service Center moved from February of 2020 to December of 2018.
Just recently?
I just checked it online because I couldn't believe what he's saying. I checked it online. Yes, it moved back to December 2018. Does it make any sense, these people, what this administration is doing? And this is the exact requirement. What we were suggesting in the beginning is that this administration really is not truthful in anything. The February 2020 was not truthful at all. If that would have been truthful, how could they change to December 2018 now? They could stuck at February of 2020. They can't just move back to 2018. This is all a deceiving that they're trying to get more money from the Congress by saying that, look, we have a backlog here. I don't know why extra money is going to make it more faster. We haven't seen it. Extra filing fees increases have not decreased the processing time. It has never done that. So this is deceiving. The USCIS February 2020 was not accurate at all. And now this December 2018 is definitely a plan to get more money for the USCIS so that they can delay our applications more. So good thing is that when this comes out in front of the Congress, we will draft a letter. It will be posted on immigrationgirl.com and also at rnlawgroup.com. I want you to contact the congressman that to put the conditions on the USCIS that they need to have the processing times up and forward so that the USCIS can receive any funds.
Sunil from Facebook is asking if a national interest waiver physician would be eligible for an exception.
I agree with this.
Okay. Mm-hmm.
Well, one question that is from Praveen is that he got the visa approved with the U.S. consulate, with the consulate in India. Can he go for stamping with a different consulate? And of course, he is thinking different consulate. If this approval that you're speaking about, Praveen, of YouTube, is that if this is, I'm sorry, Pavan of YouTube, if this approval you're speaking about of H1 or L1, no, sir. You cannot go to US consulate in India. You cannot go to any consulate. If it is about some other visa status, for example, E-visa, E-visa, P-visa, and some other visa status though, okay, O-visa, if it has been approved to one consulate, you can approach the other consulate too. Especially, for example, if assuming that there was no executive order, if you have a H-1b approval with the US consulate in Chennai, can you go to Mexico or Canada to apply for the H-1b visa stamping? Yes, you can. But please note that there is an executive order right now. No H-1Bs, no L1s, no H-4s, no L2s in any of the consulates right now. That is an executive order. But if you're speaking of any other visas, you can go to different consulate. You don't have to go to the same consulate that the USCIS has given approval for.
So Megana from Facebook is asking about his or her H-1B that is currently pending, a change of status from H-4 to H-1B, and it looks like it's pending with USCIS, and asking, can a transfer, an H-1B transfer, be filed later? So I'm assuming that this application that's pending right now is a CAP subject application that was selected in the lottery in March and then filed, in the past 3 months. So we do get this question around this time of year pretty frequently for people who were filing H-1B applications that were selected in the lottery. Can or when should I file an H-1B transfer if I want to change employers from the company that sponsored me in the lottery? So that is possible. However, we recommend waiting until October in order to file the H-1B transfer application. It may be possible to file it before that, but it could raise questions basically about the validity of the job offer for the application or the petitioner that filed for you in the lottery. If you're before October already asking to switch your job to a different employer. If it's possible, we know that depending on circumstances, it may not be possible to start with the H-1B employer who initially sponsored you in the lottery. If they are the ones who are having to lay you off after the H-1B is approved, for example, then consult an attorney and see in that situation what your best options are. But if possible, it is best to go ahead and start with the company that registered you in the lottery in October when your status changes to H-1B. Work for them for however long you can or want to before you file the H-1B transfer. Once you've hit October and you are officially in H-1B status, you can file the transfer, and it shouldn't be an issue.
Reshma from Facebook has this question. Should I use the expert opinion letter at the time of filing the H-1b application? Should I wait for the RFE to come in and then provide the expert opinion letter? Assuming that the expert opinion letter is for the specialty occupation, especially what we do is that if people don't have the specific degree, though, normally if they're from mechanical engineering background with a lot of experience in computer science, in civil engineering or industrial engineering, chemical engineering, they're working in the IT sector. We normally would like to have an expert opinion letter before we even file an application, though. But if the person, even if for electrical engineers also, it may be recommended to have a expert opinion letter on the specialty occupation before they even file an application. But if you are in a software engineering degree and then you're filing for a software engineering profession, I personally would not do an expert opinion letter when I am submitting the H-1b application. I will wait to see if there's an RFE and then we'll submit it at that point of time. This is just my judgment call. If your lawyer tells you otherwise, I am not telling that that lawyer is wrong. It's just my judgment call. This is what I would be doing it. Srinivas from YouTube has this question. His 485 application has been filed in April of 2020. And in September of 2019, he has already given biometrics at the consulate for most probably for any visa application. Does he needs to do the biometrics? Can they waive the biometrics requirement? For the 485 application, though, it's a very, at least the Trump administration, it's a very sensitive application, though. This is where you finally get the green card. I'd be very surprised if they would waive the biometrics requirement. Since you only filed in April of 2020, the processing timings are very long. For the 485 application, there is also interview requirement. We are hoping that by that time, the biometrics should be open and should be willing to accommodate all the people. So it shouldn't have much problem for you to accommodate. I'm not expecting that they will grant a waiver for the biometrics for people like you at this point of time. Another question from YouTube, Arun Nunn, is asking the question, how are they giving the H-1b approvals because of the new memorandum that was been issued by the USCIS based on the ITServe litigation? How are they determining what is the end period of time? I don't know how they're determining, but I can tell you one thing. In the preceding 2 weeks, though, I haven't seen anything less than 3 years H-1b approval. The only thing, 2 weeks, I would say. The only thing that I see less approvals, timings of lesser than 3 years is when the person is not eligible for technically. For example, if the person has used 4 years of H-1b, he's only eligible for 2 years, unless his I-140 has been approved or the labor and I-140 pending period has crossed more than 1 year. In those cases only that we have noticed any shorter period other than the 3 years period. Otherwise, we're just generally seeing 3 years of H-1b approvals.
So we're getting a lot of questions about the processing times and the effect of the furlough on the processing times. Yeah, we know that there is a lot of anxiety on that based on apparently the most recent change in the California Service Center processing time that, yeah, that does not inspire confidence, but yeah, so a lot of it we will have to wait and see, you know, what Congress does, whether they give the fund injection, whether they attach conditions, whether this furlough really takes place, or if the agency is just sort of, you know, kind of threatening the furlough of 13,000 workers as a way to, you know, try to kind of put pressure on Congress. There are some questions about whether it would affect premium processing. Premium processing is still, at this time, 15 days. We have seen a handful of cases this spring where they were filing premium processing and the processing time went past 15 days. Those cases, we think we know the reason why. They seem to all have a common issue in the request for evidence that was along the lines of the employer-employee relationship memo that was rescinded that Rahul just mentioned. So if you have a case that has gone past the 15-day clock and you had an RFE that included the employer-employee relationship issue, there's a good chance that it's past the 15-day clock because of that, because that court decision and the policy change most likely required USCIS to kind of gather all those applications that they had that similar issue and kind of wait and decide and move on them in a uniform way once that new policy memo came out a couple of weeks ago. So if you are in that situation, don't worry too much. You're not the only one. It's still a frustrating situation because when you pay the premium processing fee, USCIS is supposed to adjudicate it within 15 days or refund the additional $1,440. We have seen them in the past in some cases where, for whatever reason, they couldn't get it done within 15 days, and we've gotten a filing fee check back, or a refund basically for the petitioner. We have yet to see those refunds in the most recent cases. We are, our office, our litigation team is looking into action to kind of compel those refunds, but that's kind of the most recent going beyond the 15-day clock issue that we've seen.
Maharsh from Facebook has this question. He doesn't have an H-1b stamping in his passport. Can he go to India for getting stamped? No, you can't go to India for getting stamped. You can't go to any place to get stamped right now until December 31st of 2020. And we don't know if this executive order can be extended. So no, you're not allowed to go for stamping right now on H-1b. The next question that is from Nitin is that he has H-1b until June 2020, and he is now stuck in India. He has a H-1b, I-797 approval, but he doesn't have a visa stamping in his passport. He's stuck in India. How long can he continue working for the company? Let me tell you, Nitin, you are an Indian national. Since you are an Indian national, you are in India right now. You have no restriction to work anytime. I don't have to be an Indian lawyer to tell you that. Though I do have a license in India, but since you're an Indian national, Indian nationals do not have restriction to work in India. No restriction. Now, you are logging into USA. That does not count. At this point of time, the world, at least the countries that I know about mostly, I'm a lawyer in both the countries, USA and also in India. They do not recognize cyberspace as a space. So nobody recognizes cyberspace. So you can sit down in India, you can log into Mars, you can log into USA, you can log into any country and work in India without any restriction. There is no limit. You said that your H-1b is expiring in June 2022. Can you work after that? Absolutely. You're an Indian national. Indian nationals can work in India. And this is actually, the Trump administration made a lame excuse that COVID and unemployment is the reason for which he is actually bringing in the executive order. But the executive order is actually bringing in more jobs to India because people like you are still working in India, and which is not good for the US economy. I don't like it. I would rather want you to come here, but what to do? Under this administration policy, you can work, absolutely no restriction for you to work in India for you. Absolutely no restriction.
So we had a question on whether the use of Medicaid would need to be disclosed on an I-539 application in response to the public charge rule questions. The answer is yes. There are questions on the form about Medicaid, and so if you have used it, you need to disclose it. Read the question carefully and make sure whether it applies to you or not. That doesn't necessarily mean that you are considered a public charge. The public charge determination is supposed to be a totality of circumstances situation. So I believe the person who asked the question.
One small thing is that the particular question was saying that in 2012, though.
Oh, sorry. I thought it said more recently. We may have been looking at more than one question. Yeah, if it was, it's also time limited. So something from 2012 is not required to be disclosed. I believe within the past 3 years, it does need to be. So make sure you read the question carefully. If it's outside of the required amount of time, you don't need to disclose it. If it is, even if it was a one-time situation, an emergency situation, and you haven't used it since, you do still need to disclose it to avoid any misrepresentation claims, but you can make clear from the rest of your application that you are not otherwise susceptible to being a public charge based on your income, credit history, other factors.
Last question, Rebecca, that I'm going to take. Questions from Srikanth. Is birth certificate necessary for filing an I-140 application? No, it's not needed at all to file an I-140 application. Any other things that you want to close before we close, Rebecca?
I had seen a few questions about Canadians and automatic revalidation. At this time, it seems like the executive order does not affect people who would not need to apply for a new visa before re-entering the US. And so that does seem to mean Canadian citizens who are visa exempt, who do not need to get a visa from the consulate. They can apply for the L1 directly at the border, for example. It seems like they can still do so under the executive order. And automatic revalidation, we saw some questions about that. If you meet the terms of automatic revalidation, it seems like you can still travel between the US and Canada or Mexico based on that without having to go to the consulate for a new visa stamp.
Thank you guys for logging in. Don't forget that we are also collecting in emails for the people who wants to protect the H-4 EAD. Emily Neumann, our business partner, is trying to collect all the information from a lot of people. If the H-4 EAD is being taken off, she would like to litigate the issue of the H-4 EAD in the court. As we have seen historically, whenever the Trump administration has tried to ban the EADs, the court came in favor of the EAD applicants, especially in the DACA and other cases too. So we would like to take the litigation part of it, but we want you to be part of it. Just go to immigrationgirl.com. Please register your email address so that when the H-4 EAD will be taken off, you can be a part of the litigation to get this H-4 EAD. If you want to make an appointment with me, Rebecca, or any of our colleagues, you can always go to RN Law Group and make an appointment with any of us. Thank you guys for logging in.
Thank you.